Thanks for joining in, everyone. We will get started in just a minute. Great to see people joining in. Really appreciate that. I will get us going in just a minute. Good morning to those on my side of the world, and good afternoon to those in Europe and other parts of the world. I'm Jeff Abramson. I am the director of the Forum on the Arms Trade, and I'm very happy to welcome you all to this event. I will speak for a little bit, mostly about the technology, and then I will turn it over. But Forum on the Arms Trade is a network of professional civil society members deal with the implications of the arms trade, security assistance, and weapons use. This month, we are actually celebrating our 10th anniversary, which is very exciting. And we have a week of events this week, looking ahead to 2025. This is the second event. If you would like, please feel free to join us for the next events. There's one a day, which is an ambitious way to get started, but there are so many issues to take on. I wanted to share a little bit about uh, the technology that we'll be using for today's event. Please put your questions in the Q&A. I know many of us have been at plenty of Zoom webinars. You may also see each other's questions and upvote those questions, which will help us know which ones are most popular. We also will have the chat function enabled as long as it remains respectful. Please feel free to use the chat. We feel that's a good way for audience members to interact with each other, but I don't want it's too hard for the panelists to sort of follow the chat. So the chat will be mostly used for you all to participate with each other. At the end, there will be a quick survey that pops up. If you could please take that survey to give us some feedback. We're always looking to improve and to figure out how these events went. Today's event is Evolving Legal Challenges to the Arms Trade in 2025. Almost exactly a year ago, one of our panelists, Shahd, participated in an event that was very similar, looking at arms to Israel. And later last year, Leon participated in an event that was related to arms to Mexico. So we're really delighted to be taking on this topic. I want to make clear that the Forum on the Arms Trade itself does not take positions, but does provide a platform for others. You are going to hear, I believe, a lot of criticism of Israel, as well as the countries providing arms to Israel. That is certainly possible to also occur while also condemning the actions of Hamas on October 7th of 2023. Those things are not mutually exclusive, so please keep an open mind. And I'm really delighted to turn this over now to Leon Castellano-Jankowicz, who is a senior researcher at the Asser Institute for International and European Law at The Hague. Leon will introduce himself further, set the course for the panel, and talk with you about the speakers. Leon, over to you, and thanks so much, everybody.
Thank you so much, Jeff, for this introduction. My name is Leon Castellanos-Jankowicz, and as Jeff said, I'm a senior researcher at the Asser Institute for International and European Law, and I supervise the International Law Clinic on Access to Justice for Gun Violence at the University of Amsterdam. And it is my pleasure to be here with you today with three wonderful scholars on the arms trade and international law and human rights to discuss evolving legal challenges on the arms trade. I think it's a very fitting moment to have this session, and I really would like to thank the Forum of the Arms Trade for dedicating a space in order to have this discussion, because 1 year ago, almost to the day, the International Court of Justice issued an important order on provisional measures, as we all know, in the case of South Africa versus Israel. So what's happened since? Where are we going towards? And what kinds of cases can we see coming up in the future? Of course, 2024 was a very important year in terms of litigation regarding the arms trade, especially when it comes to contributing towards Israeli arms and weapons, because of the catalyzing effect of the International Court of Justice's decision. So our colleagues, Shahd Hammouri, Marina Aksenova, and James Yap are going to share their views with us today, and I welcome them all. I'll start. I'm going to have 2 rounds of questions for our panelists, and I will start first with the kickoff question to Shahd, which I'll ask after introducing her, of course. Shahd Hammouri is a lecturer in international law and legal theory at the University of Kent, and is the author of a forthcoming book titled Corporate War Profiteering and International Law. She is also a senior legal advisor for Palestine and non-resident fellow at Al-Haq for Applied International Law, also in Palestine. Shahd, welcome to this exchange. It's a pleasure to have you here. Shahd, the first question has to do with the growing number of cases we saw last year in the UK, the US, and Europe against state licensing authorities contesting the transfer of arms to Israel. So could you give us an overview, please, of what those cases are about and where those cases are right now?
Thank you so much for that, Leon. And as kindly noted by Jeff, this is 1 year after our prior webinar. And indeed, it's quite tragic that we're still in the same circumstances. Yet last year, we were speaking of possibilities. This year, we are speaking of actual realities happening in international courts. So to begin with, what are these cases relying on? That's what I'll elaborate on. And then I will give a little bit of a taster of what's happening, as I have very limited time since there's so much. So to begin with, the cases are relying, as Jeff noted, and Leon, we have the ICJ case last January, which talked about the plausibility of genocide, herein enacting state duty to prevent genocide. We also have the advisory opinion by the International Court of Justice, which we'll talk about later on, but more or less gives us the state duty to cooperate towards ending the illegal occupation of Palestine. And most recently, we've also had the arrest warrants being issued by the ICC, which ascertained that there are violations of international criminal law, which opened leeway, let's say, and actually breathed life back into some of the litigation happening. Of course, we're also looking at the EU code on the transit of weapons. We're also looking at the Arms Trade Treaty, which says that states have the duty not to license when they have knowledge that the weapons will be used in contravention to international humanitarian law. So there is a broad legal framework here. Different cases are relying on different aspects of that. But in short, it is safe to say that states have a clear duty of imposing an arms embargo on Israel. That duty does indeed extend towards the transit of weapons as well as jet fuels. That is, if we understand the case of Palestine, building on the precedents of other cases of colonization in international law. The first issue that we are facing is an issue of information. Herein, we saw a lot of organizations seek to submit as much information as possible on the usage of arms in Gaza and the West Bank through submissions. For example, in the UK, we saw submissions to the Secretary of Trade and Business, as well as MPs. Further, we saw a lot of rise in Freedom of Information Act requests. A good example here is Belgium, where they used Freedom of Information Act in relation to the environment in order to get information about the transit of weapons. We also saw requests for disclosure of legal advice, which was taken forward in the UK as to what legal advice was given to the government. Then there was a lot of cease and desist letters. For example, the Center for Constitutional Rights has engaged extensively in that towards the corporations. The big thing and the big theme here indeed is judicial review. The most notable example here being the UK. The UK, after a first round of adjudication, we're now looking at the second round of adjudication, where we have judicial review against the state. This new round seeks to challenge the limitations put forth by the courts in the first round. What we saw is an attempt by the UK to put ahead obligations that are owed under the NATO agreement, as well as foreign policy considerations that put the US interest forward. We are now expecting to hear on the proceedings earliest by March in relation to the UK case. Meanwhile, in the Netherlands, we're also looking at a second round of litigation, this time a civil case challenging state conduct by refusing to impose a blanket embargo. In the case of the UK and the Netherlands, we find the same reluctance, and this reluctance is in relation to the F-35 program. And for those who are not familiar, it is a program under the NATO that facilitates the repair as well as the construction of F-35 warplanes. And indeed, a good part of these warplanes do end up in Israel, and these are the same warplanes dropping bombs on Gaza. So the involvement of different state actors has been an important topic in litigation, and we've seen a lot of reluctance by states to review their policy and engagement with the F-35. In the UK, there was a carve out of the review in relation to the F-35 program. Furthermore, we are looking in Denmark, where there is a case that is based on the Danish Weapons Act alongside the Genocide Convention and other acts. However, that case is still in the procedural hearing phase, and we're looking at that also early this year, but the litigation is expected to take a few years. Meanwhile, in Germany, there was an avalanche of proceedings, and here we're looking at mostly administrative proceedings with a little use of criminal law. Despite the fact that most of them have failed, actually, we have seen quite a good effect in relation to policy making, because the state has frozen some of its licenses in response to these cases, and also in response to fear of being found guilty, in order to push for their own defense in these cases. Nevertheless, we are fearfully looking towards a change in that policy of freezing the licenses now with the Trump administration coming in, that will further embolden the government. Furthermore, we are looking in India. There was a case that reached all the way to the Supreme Court, and again here the Supreme Court ruled that this decision falls outside of the remits of what the Supreme Court itself has jurisdiction to say. We also saw another creative use of local councils and decisions by local councils. So, for example, the Walloon district in Belgium has taken a decision not to transit weapons or allow the export of weapons from its region, and the Walloon district is in Belgium. We've also seen a lot of litigation in relation to the transit of weapons, as well as parliamentary requests and positions on that within the states. I'm presuming that I have run out of time. Is that correct, Leon?
Thank you so much, Shahd. We'll come back to some of these points in the second round, so feel free to address them then. But I think that you've provided a very useful sort of baseline for us to continue the discussion, giving examples of really what is worldwide, litigation, spurred again by the the order of the International Court of Justice of last year. To my mind, that is unprecedented level of activity and interest in the arms trade, including, of course, not only the behavior and decisions of states and licensing authorities, but also the obligations and duties of corporations and their duty to respect human rights and due diligence. This point brings me now to our second panelist, Marina Aksenova. Marina is Associate Professor of International Criminal Law at IE University in Madrid and founder of the Art and International Justice Initiative. She has worked at the UN International Criminal Tribunal for the former Yugoslavia, the Extraordinary Chambers in the Courts of Cambodia, and White and Case. Her first book, Complicity in International Criminal Law, was published by Hart in 2016 and won multiple prizes, including, most recently, the Paul Guggenheim Award at my alma mater, the Geneva Graduate Institute. Welcome, Marina. It's a pleasure to have you with us. Marina, my question goes to, as I said, the obligations of corporations. And as you know, these businesses play a big role in ensuring the prevention of downstream damage and supply chain due diligence. And so have there been any significant legal developments in corporate responsibility or liability for arms transfers recently? And are you aware of how they might develop in the future?
Thank you so much for this introduction and for your question, Leon. It's a pleasure to be here. And as you mentioned, I'm an international lawyer above all, so I will start my answer by outlining the overall legislative framework from the perspective of international law. So it is quite difficult to regulate corporations from the perspective of international law, because as we know, corporations are not strictly speaking subjects of international law. However, we have soft law instruments such as UN principles on business and human rights and a plethora of other soft law instruments, as well as general due diligence obligations on corporations that could be enforced through the states. So what I saw last year and what I envisage for the upcoming years to come is the evolution of understanding of due diligence and evolution of due diligence with respect to weapons trade as well. And in this regard, we saw developments at an international level, at the regional level, and also at a state level. And Shahd very helpfully outlined some of the cases brought against corporations or against licensing agencies at a state level. So what I see to be one of the biggest problems when bringing corporations accountable at a state or regional or international level is that states introduce security exceptions. They introduce protections based on national security interests, and this is done also because state licensing agencies are very much entangled and connected to the corporations. So what we saw in the last year is somewhat beginning of disentanglement of these two processes. So the process of granting licenses and the process of due diligence by corporations. So what happened at an international level? I will just outline one important development is the case brought by Nicaragua against Germany under the Convention on Genocide. And Nicaragua, amongst other things, requested provisional measures that included halting supplies of weapons to Israel. The International Court of Justice rejected this request for provisional measures. However, there was very clear conversation about due diligence obligations of Germany, and Germany had to provide support for its claims that it conducts due diligence obligations. And the court was very clear in stating that this assessment needs to be made. So in this case, there were no provisional measures ordered, but there was a conversation in which factually Germany had to prove that they submitted that they supplied less and less weapons to Israel after the beginning of active conflict in last year. So this is an international level development. Then we have, of course, a development at a regional level. At an EU level, we have famous 2024 Corporate Sustainability Due Diligence Directive, which, Leon, I'm sure you are very well aware of too. And it excludes weapons trade from its purview. However, it creates a very important process of tracking due diligence in the course of the whole supply chain. So that creates a certain granularity in our approach to corporate accountability in general. It sets a precedent as to how we assess corporate conduct. So my prediction is that we are going to see more and more granular approach to due diligence obligations of companies. Even if weapons manufacturers are expressly excluded right now, we're going to see evolution of the general process of due diligence. And then, of course, we have EU AI Act, which is going to have an impact on how we understand automated decision-making, and especially AI-generated decision algorithms that are used in the weapons trade and also in weapons. And I will speak in the second part of my answer more specifically as to what AI has to do with weapons and weapons trade. And then we have a EU Council 2023 document on the project of promoting effective weapons control. So we have certain developments at the EU level that will have an impact on corporate accountability. And then at the national level, of course, we have three conflicts right now, which are very much within the purview of courts. And we have more conflicts going on, but the courts pay a lot of attention to these three conflicts in Yemen, which is now a bit less prominent, Gaza and Ukraine. And we already mentioned this case with F-35 fighter jets. And this case has been decided by the appeals court in The Hague in February, instructing halting of weapon supplies to Israel. However, it was partially reviewed in July by the district court in The Hague, saying that only supplies from the Netherlands should be prohibited, but supplies via the United States should be allowed. But now we're seeing the evolution of this case because it's brought now to the Supreme Court in the Netherlands, and the Advocate General issued their opinion saying that the initial decision needs to be supported, namely very strict due diligence for supplying parts to Israel. So regardless of whether it's through the Netherlands or the US. And this is important because the second decision created a loophole which could have been exploited in a sense. So I think we're going to see more of this type of litigations. And I will conclude this part of my answer also with talking a little bit about Ukraine, because we have not seen active assessment of the quality of decisions with respect to weapon supplies to Ukraine. They've been done, for example, within the EU using the fast track procedure. And I suspect that in the future, there will be some review mechanisms because there are certain obligations under the Arms Trade Treaty and also the EU Council Common Position to assess, for instance, whether the supply of weapons contributes to prolonging the conflict or whether the weapons are at risk of diversion. And this is going to be something that's going to be assessed. And the final point, which I think is important to mention, is the authorization of the use of anti-personnel mines in Ukraine by the United States and the supply of anti-personnel mines, because this is in violation of the Ottawa treaty obligation. So this will potentially create basis of liability, tort liability, and other forms of liability in the future. Thank you.
Great. Thank you, Marina, for going through all of these. I think it's very important to highlight the game-changing nature of due diligence, as you said, and how it's going to be trickling down to different areas, right, of liability, especially when it comes to the behavior of corporations. And here I would like to emphasize tort or civil liability, as it's called in different jurisdictions, because sometimes international law doesn't trigger a domestic claim in the courts, but civil tort or a civil claim is a much easier way, right? A route to get victims, to get redress for victims. And due diligence is part of that process. If the due diligence procedure is not undertaken comprehensively through the entire supply chain or the value chain, then that gives rise to a claim under civil law. And we've seen a lot of cases, for example, in the relating to the climate, are triggered by civil liability clauses or duty of care obligations, which are also civil liability. Let me now turn to, so thank you very much, Marina, for that overview. Let me now turn to our third panelist, James Yap. James, you are acting director of the International Human Rights Program at the University of Toronto Faculty of Law and adjunct professor of International Human Rights Law at Osgoode Hall Law School at York University. You are also a practicing lawyer specializing in the human rights accountability of multinational businesses, as well as the application of international human rights law in domestic courts. Welcome, James. Thank you very much for being here. James,
Thanks so much, Lee.
thank you. My first question to you, James, is related to the Israel-Gaza situation in the Middle East. So could you give us the view from Canada and North America in terms of strategic litigation, especially since the Canadian military industry is closely integrated into its US counterparts?
Yeah, thanks so much, Leon. And so I'll just do a quick summary of the Canadian litigation, its current status, and some of the strategies that we've been adopting. So by way of background, the arms export regime in Canada is governed by a permits-based system, which means that an arms exporter must apply for a permit from the government in order to export arms from the country. Similarly, Canada is also party to the Arms Trade Treaty, just like many of the countries we're talking about today, which means that under international law, Canada cannot issue a permit to export arms if there's a risk that those arms will be used to commit or facilitate a serious violation of international humanitarian law or international human rights law. So we filed a case against the Canadian government in March, and the object of the case was to declare invalid all the permits to issue arms, all the permits issued to export arms to Israel after October 7th, 2023. The legal basis of that case was the domestic implementing legislation of the Arms Trade Treaty. So the legislation that brought the standards of the Arms Trade Treaty regarding export licenses into domestic law, as well as elements of the Canadian Constitution, the Canadian equivalent of the U.S. Bill of Rights, specifically the part of the Canadian Constitution dealing with the right to life, so the equivalent of, roughly speaking, of Article 6 of the ICCPR, or the Due Process Clause of the U.S. Bill of Rights, as well as the equality rights provisions of the Canadian Constitution. So that's the Article 26 of the ICCPR, or the Equal Protection Clause of the U.S. Bill of Rights for U.S. constitutional lawyers. And so we filed that case in March. A few weeks afterwards, the Canadian government actually announced, as a result of public pressure campaigns, that they would stop the issuance of permits to export arms to Israel directly. And again, that announcement came as a result of a very large and well-coordinated national public advocacy campaign. But despite that major win and that progress, the case still continues for a number of reasons. One is that the announcement of the government that it would stop issuing permits to export arms directly to Israel, that decision can be reversed at any moment. Not only can the decision itself be changed, but the government itself could change at any moment, and another government could come in that would take a different approach. And in fact, that is something that is quite possibly about to happen here in Canada, if you haven't been keeping abreast of Canadian political developments. Not only that, but the flow of direct arms exports from Canada to Israel actually constitutes only a small proportion of the total flow of Canadian arms exports to Israel. A much larger proportion of Canadian arms exports to Israel actually goes there directly through the United States. And so by way of background, Canada and the US have a very close military relationship and alliance, and this extends to industrial policy. And through a series of international agreements and coordination, they've established actually Canada. The Canadian military industry is very highly integrated into the U.S. military industry, into what is often referred to as a single North American military industry. So parts and components go back and forth across the border, permit-free. So Canadian arms exporters, whereas to export to Israel or basically any other country, would have to apply for a permit from the government to export. If they want to export the same goods to the US, for most military exports, they do not need to apply for a permit at all. So permits can go to, exports can go from Canada to the US without a permit. And so, again, this facilitates the integration of the two military industries, such that Canadian parts and components are that move freely from Canada to the US are a big element and go into a lot of larger US-made weapon systems that are then provided from the US to Israel. And not just in terms of parts and components, but also weapons themselves can simply be instead of weapons themselves that cannot go to Israel directly without a permit, can simply be rerouted through the US and don't need a permit to do so. So for instance, in August, some may remember there was an announcement of a major foreign military sale to Israel. It had to be announced because it met the congressional threshold in the US for when a foreign military sale needs to be have notification to Congress. And as part of that announcement, the package was mostly a number of F-15s, but part of the package was, I think, 50,000 mortar shells worth $60 million that were to be purchased from Canada, and they were simply going to purchase them from Canada and turn around and flip them to Israel. So these were goods that could not have been exported to Israel directly without a permit, which the government of Canada claims that it was not issuing at the time. But instead, what they were simply able to do was to purchase them from the US and then from the US sell them onwards to Israel. So that's a major loophole. And so the Canadian litigation is also going to focus on closing that loophole and closing or ending the permit-free movement of arms to the US without export controls and also without re-export controls, because the US arms exports that go to Canada without a permit, similarly, are subject to re-export controls. So any arms exports that go to the US from Canada without a permit, the US still imposes controls on the re-export of those arms from Canada to a third country. But Canada does not have the reciprocal re-export controls for Canadian goods that go from Canada to the US without a permit. So that is a key element of our strategy, is to go after indirect arms exports to Israel through the US. And then another part of our strategy has also been to be active in international tribunals and organizations and UN tribunals and bodies. So for instance, the CEDAW committee, UN Women's Rights Committee, did its periodic review of Canada's record on women's rights last fall, and we submitted a report for the periodic review talking about the role of Canadian arms exports to Israel in serious violations of women's rights in Gaza. And so the CEDAW committee released its findings and urged Canada to do more to stop arms exports to Israel. And similarly, we are filing a submission to the CRPD committee, which is a UN committee on disability rights, similarly arguing or similarly talking about the role of Canadian arms exports in contributing to serious violations of disability rights in Gaza. And we are going to make similar submissions to the Inter-American Commission. We're going to make another submission to the third committee, which is the UN committee on racial discrimination, in the hopes of slowly building a consensus in all these international human rights bodies and tribunals, and increasing pressure on the Canadian government through these international bodies, and hopefully building some kind of consensus on international law on the indirect transfer of arms exports to Israel, which we hope will percolate into the domestic legal sphere as well. Thanks. I'll stop there for now.
Thank you, James. I think it's very interesting to learn about the integration between Canadian and American military industrial production. I think it is very important. It raises important questions regarding traceability, right? To what extent do the Canadian goods, can they be traced back to the source if they cause damage, war crimes, crimes against humanity, etc. So I think very important questions when it comes to liability, not just of the government of Canada for its policy-making decisions, but also for the corporations which are producing these goods. It reminds me as well, going back to the session that was organized yesterday, about what Europe is trying to do right now, which is enhance its military-industrial base and production and sourcing in order to raise its capacity and stand up to adversaries in the region, such as Russia. And this raises important questions, right? To what extent does the responsibility or liability of one state end, and the responsibility and liability of the next state begin when you are in a joint project of sourcing and acquisition and arms production? So important questions here, and I'm mentioning this as well because we have an interesting comment here by Natalie Davidson, who is asking, why do we have so much attention and interest in human rights standards when it comes to arms production and arms trade, while at the same time having also a geared up activity when it comes to states cooperating in order to increase their capacity in terms of production? And so how can we square that circle? Feel free to address this in the second round. Thank you, Natalie, for the great question. Let me go back to Shahd now, and for the second round, after which we will have some time for Q&A. Shahd, as you know, as we all know, we had a very important advisory opinion in the ICJ last year as well regarding the status of the occupied Palestinian territories. The ICJ said some important things about the obligations of third states deriving from its findings. So could you tell us a little bit about those, and what implications do those have for possible litigation looking into 2025?
Thank you for that, Leon. So to start with, this decision came after almost 57 years of Palestinian requests for such a decision. And in short, the court found that Israel is in violation of at least 3 preemptory norms of international law, including the prohibition against aggression, the prohibition against racial discrimination and apartheid, and the protection of the people's right of self-determination. When we have violations of preemptory norms of international law, that means that states, even third states, have direct obligations of cooperation and non-recognition towards that grave illegality at hand. And here the court directly, and also adding to that the fact that Israel has been partaking in a plausible genocide, as well as illegal acts of aggression in both Lebanon and Syria. Adding to that, the full-rounded picture of Israel committing crimes against international peace and security. And when you look at the violations that were given by the court, you will have the full picture. This full picture is simply colonization, alien domination, and subjugation. Once we establish it like that, we're capable of looking at precedents such as Namibia, Angola, South Africa, of previously colonized states in order to establish what third state responsibility in this case looks like. In paragraph 278, the court told us that states have the duty to prevent trade or investment relations that assist in the maintenance of the illegal situation in the occupied Palestinian territories. And of course, this is a very difficult question. What type of international economic agreements would facilitate that? Of course, the arms trade here comes as the very clear suspect and the first industry that we can think of in terms of state obligations here. What does that mean for us? It means that we have a state that is in violation of preemptory norms of international law, and from that there is third state responsibilities. And as many other scholars have noted, it's as if the ICJ has given the BDS the green light. And for that end, it is important to recall that, for example, in Article 53 of the Vienna Convention, if a specific obligation in a treaty is in contravention to a jus cogens norm, then the jus cogens norm prevails. And that's quite important. It tells us that, for example, in the case of the transit of weapons through the Suez Canal in Egypt, when the activists sought to stop the Egyptian government from partaking in that using legal language, the Egyptian authorities responded, citing a pre-existing treaty obligations in order to facilitate the transit of even military ships across the Suez Canal. However, the response in this case, relying on the advisory opinion, allows us to say that the state's duty in this case indeed does override the treaty duties, and of course here adding to that the duty to prevent genocide. And of course it's a very logical thing. You have a quote unquote plausible, though of course many agree in calling it a genocide happening next door. The least you could do is not facilitate the direct transit of weapons to that. Furthermore, when we look at the implications of that in trade law, though that's not directly relevant to the arms trade, however, that could facilitate in breaking down the value chain, since the US, the main supplier of weapons here, it doesn't seem to be changing its position. Article 21 of the GATT allows for exceptions in relation to measures in pursuance of obligations under the UN Charter, which means that states have a green light in order to get out of their trade obligations if that is in compliance with their third state responsibility in response to the grave illegalities committed by Israel. So what are the challenges that we are facing in this case? The cases that I described before, of course, we've seen a lot of reluctance, and that reluctance has manifested in issues relevant to that, of course, in the indeterminacy of the law. They have manifested in relation to issues on jurisdiction, standing, of course, a lot of lack of transparency in violation of the Arms Trade Treaty, and misinformation. For example, with the US, we've gone through an insistent loop with US officials, more or less denying outright reality of what is happening on the ground in Gaza. As we've seen also in Canada, there's an issue with end use of the weapons as well as diversion. We've also, the main problem that we are facing is arguments that are premised on NATO obligations. It is very important to recall that at no point NATO obligations are allowed to override international legal obligations. And it's very sad to see state representatives as well as lawyers partake in this security carve out of international law. Indeed, these are international law is between politics and the law, and indeed these questions will have to be international legal questions. More or less, also we're seeing the excessive use of economic coercion by the United States of America, and by that I mean, as we've seen last week, the US is moving towards defunding the ICC. There's a lot of discussion about the defunding of the United Nations, but also there is discussion and there is active effort by the US to impose economic measures on states that seek to enact their third state responsibility in compliance with international law. Here we're looking at both Ireland and Spain that have, as well as South Africa, that have been seeing the specter of trade restrictions against them being taken forward. In this case, it's important to recall in the annex of the Vienna Convention on Treaties, there is a direct reference to the prohibition against the use of economic coercion. Sadly, that clause in relation to understanding, of course, economic coercion is what facilitates neocolonialism as we know it today. So it wasn't in the benefit of states of the global north to articulate economic coercion in the Vienna Convention, sadly. However, it still exists in the annex, and it's important to call things by their name in relation to what the US is doing. So in short, the decision is here to take us forward, and we are still expecting a lot of litigation, not just in relation to the arms trade transfer and energy, but also towards larger aspects, specifically in the tech industry and as Marina has noted, AI and the like. The question here is not exactly how is it to differentiate economic dealings, but rather what is the purpose of third state responsibility here? The purpose of third state responsibility is to protect the Palestinian people against irreparable damage. And I'll get to the question in the Q&A session, since I'm presuming I ran out of time.
Great, thank you so much, Shahd, for that overview of the consequences of the advisory opinion. I think that it is interesting to think about other cases as well. A question in the Q&A also mentions examples from Myanmar, right? There is a lot of cases coming up, not just in South Africa, where which has been mentioned in the question, but also here in Europe. I believe there is an ongoing case in Germany relating to some Danish and German parts being exported to Myanmar, and of course cases in the US against gun companies brought by Mexico. So definitely a lot more happening in the space. And so hopefully we have another event soon here. Actually, the Mexico case is being discussed later this week here in this series. Marina, let me follow up with some of the points that you mentioned and also something that Shahd said. So the ICC has also issued an arrest warrant against Netanyahu and Gallant. So that definitely, raises the prospect of individual criminal liability for these persons and certain ramifications possibly when it comes to responsibility. So could you talk a little bit about those and what they mean moving forward?
Thank you for these questions, Leon, and I will get back to the ICC. But before that, I wanted to address the question of Natalie, because it links very nicely to the topic of public international law and international criminal law. What relevance does it have on private companies, but also, as I understood Natalie's question, is how do we square the circle? Increased militarization, and then here we're discussing somewhat positive developments on holding companies accountable or holding states accountable. How does it work together? So it has to do, for me, with due diligence obligations, what you mentioned before. The due diligence obligations are being worked on right now. This is not an independent basis for obligations for companies or states. This is a standard of care which we use to interpret the Arms Trade Treaty, human rights documents, the Rome Statute of the ICC. This is a particular way of interpreting. And the positive side is that we see more and more attention directed to weapons trade. We see the International Court of Justice talking about it. We now will see the ICC possibly talking about some aspects of weapons trade. So all of this conversation and the civil society action creates certain expectations and certain interpretative guidance. So this is, for me, glass half full. And I'm so glad Shahd mentioned sanctions and economic coercion. I'm quite critical of the sanctions in general, but I think that the side effect or the silver lining of the enhanced use of sanctions is that it is much more difficult right now to divert weapons through a third country. So this is what we see with with the attempt of the Dutch District Court to say, well, it's okay if the weapons go through the United States. But now that we see that it's very difficult to avoid responsibility as a third state, this is the side effect of the sanctions. This also adds to our due diligence expectations and due diligence obligations as they are interpreted in relation to particular legal documents setting out substantive standards. So this was the overall paradigm, and you asked, Leon, about the ICC. So the impact, as you say, it's quite limited if we speak about corporate accountability, because the ICC does not deal with the responsibility of legal entities. It only deals with individual criminal responsibility. And this decision to issue the arrest warrants is relevant for seeing superior liability with respect to intentional targeting of civilians. This is one of the charges. We don't know much because the arrest warrants are still under seal, but there is an explanation on the website of the ICC as to which specific charges the prosecution brings. And many of us know about starvation and crimes against humanity, but also both leaders of Israel were charged with intentionally directing attacks against civilian population. And this is where there is a possibility to assess the quality of decision-making when it comes to employing weapons. And here I'm referring to the work of Marta Bo, who wrote a wonderful blog on Opinio Juris about the use of AI decision-making in targeting civilians in the Gaza conflict. And the ICC is likely to look at the margin of error done by artificial intelligence as to whether it constitutes indiscriminate targeting of civilians, and just generally interpret international humanitarian law through the lens of international criminal law when it comes to the use of weapons and when it comes to the use of artificial intelligence in targeting civilians. So this is quite a narrow scope from the perspective of the overall question of weapons trade, but it again adds to creating certain expectations on companies as a basis for further litigations. So we will see more scrutiny of technology, more scrutiny of what goes into the production of weapons if these charges move forward. So that would be one very important development. And of course, I cannot not mention the other case that the European Center for Constitutional and Human Rights tried to bring to the ICC, which, Leon, you know a lot about as well. It's the case against European manufacturers of weapons in relation to crimes committed in Yemen by Saudi Arabia. So the complicity, potential complicity of European manufacturers, this communication has been brought to the ICC in 2019. We still have not seen the decision, but this is also an important element in the general definition of the standards of what we expect from corporate leaders and corporate companies and those who head the companies. And as I said, it's only individual criminal responsibility, but heads of corporations can be held accountable at the ICC as individuals. So I will stop here and hopefully there's time for questions. Thank you.
Thank you so much, Marina. Indeed, let us move on so that we can get some Q&A going on here. So James, to conclude, what can we expect moving forward when it comes to cooperation with the US, whether it's intergovernmental or through private corporations supporting any kind of military effort which is controversial, including, of course, in the Middle East? And the million-dollar question, how does the Trump presidency, right, change this outlook?
Yeah, so I think one thing you can expect to see, and I'll try to be quick, one thing you can expect to see, and I think really only makes too much sense, is a shift internationally from focusing on arms embargo on Israel, more to looking at an arms embargo targeting the United States. It only makes sense. Take a look at a country like Canada. Canada statistically supplies less than 1% of Israel's total arms imports. The US, on the other hand, supplies 70% of Israel's arms imports. So you see, Canada has very little leverage directly on Israel. However, as I described, Canada has a whole lot more leverage on the United States itself. As I described, it's very integrated into the US military industry, provides a lot of parts and components that go into things like F-35s, F-15s, F-16s, etc. It's not just Canada. As my colleagues have gone into, countries like the Netherlands, countries like the UK, they're finding out the same thing. It's one thing to stop arms exports directly to Israel, but it means little when arms exports can and parts and components can simply be rerouted through Israel through the United States. So at the same time, the US military industry supply chain is very international. Take the F-35 program, for example. I think there's something like 8 international partners, including Canada, the UK, the Netherlands, a number of other countries. And that the sort of international supply chain distributed throughout its network of the US network of allies is seen in a lot of ways or set up as a strategic strength. In many ways, it can also be a strategic vulnerability in the sense that it leaves the US military industry supply chain vulnerable to a coordinated legal and public advocacy attack to try and disrupt the supply chain of the US military industry. And like any part of that chain, any small court victory could, in theory, gum up the entire supply chain. The Trump presidency, in fact, in my opinion, provides a because if this presidency is anything like the previous Trump presidency, you're going to see a lot of strain placed on the relationships between the U.S. and a lot of its allies. So in a lot of ways, the Trump presidency provides an opening, an opportunity to try and disrupt a lot of these military-industrial relationships. So I think you're going to see a more coordinated legal campaign and public advocacy campaign to try and disrupt the supply chain of the U.S. military industry. And I think you're going to see a lot more coordination between advocates in different countries as well, whereas as I and my colleagues have described, a lot of countries are finding the same thing, that the key is really to not just to disrupt arms exports directly to Israel, but also to disrupt arms exports that go to Israel through the U.S.
Great, James. Thank you very much for that. Ladies and gentlemen, we have 4 minutes for questions. And if anyone would like to use the Q&A in writing, or please raise your hand and I'll give you the floor if you would like to use the microphone. So I will wait a moment, but if there are no questions from the audience, I'll have a round of closing remarks from our speakers, as suggested by Jeff in the chat. Definitely lots of issues, more questions than answers raised throughout the presentations, which is always great in a session like this, especially when it comes to looking forward. I don't think that there are any questions at this point, so why don't we just go around with 1 minute for each of our speakers, and of course we thank them all for their input and their thoughts. We're going to be following up on these issues here in the Forum of the Arms Trade, and I'll hand over now to Shahd, who is going to share her 1 minute of closing remarks.
Yeah, so I didn't have anything in mind to end on, but building on the inquiry based, we are looking towards a more militarized year, yes, and we are looking towards further challenges, and this is a political move. What we are trying to do is to leverage spaces of the law in order to protect those who are most vulnerable. And in the case of Palestine, this goes another step forward in relation to prior movements towards an arms embargo of a state. Think of South Africa, for example. Whether or not we will be seeing this, one of the main reasons this hasn't happened in the UN General Assembly is, again, because of political coercion and the lack of political will. But at the same time, this just makes this type of work much more important because that's what the people on the ground are waiting for. So I think that the message going forward is we've seen much more creativity this year in approaches. We're hoping that the future also, when we talk to corporations, when we talk to states, in cases like the case of Palestine, you're expecting an ad hoc mechanism in the future, a criminal ad hoc mechanism in the future. We are definitely in need of finding all the different ways possible, and also to think of strategic litigation for the arms also as a political act that is inherently engaged towards the protection of the people. We can't do this in absence of course, this very politicized topic of the arms trade. And in reality, we're talking about very bloody reality. And the only way we could seek forms of accountability first is by making such illegalities really expensive, but of course, too, by paving the way towards a more just future and making meaning out of the ongoing atrocities. Thank you.
Thank you, Shahd, for those final thoughts. Marina?
Wow, these were beautiful thoughts. And just following up on what Shahd was mentioning, it is essentially a political question to a large extent, everything related to weapons trade. And that was one of the problems for a long time of the weapons trade, that it was a very obscure industry because of the national security and foreign policy situation. And what I predict for the next year to come is that we are going to see more legalization of the discourse around weapons trade. Shahd mentioned the word creativity, but we can also use the word scrutiny or just conversations and bringing it to the purview of civil society. So I think already having a discussion and having legal concepts applied to the question of weapons trade and trying to connect the end result, not just crimes, but also supplies of weapons to particular countries and how these weapons are used, and the authorization, just trying to bring it together is already a big step forward, and trying to create a paradigm, a legal framework where this all fields of law, international, regional law, domestic law, they interact with each other. Thank you.
Excellent. Thank you so much, Marina, for those timely thoughts. And now finally, James.
Yeah, thanks so much. And I'm going to continue on with my colleagues the theme that they started and talk about politics. Just to say that anyone who's worked in international human rights knows that the language of international human rights is very limiting and obscures a lot of the politics but behind international human rights violations and situations and crises. And it's important when talking about the arms trade and human rights not to lose sight of the broader political issues that are behind this whole dynamic, such as imperialism, colonialism, global capitalism. This is why it's important to talk about the arms trade, not just in terms of direct arms exports to Israel, but also to talk about the responsibility of the US. And the US is a major backer of Israel, because this whole situation, it's broader than Palestine. It's a microcosm of so many dynamics that have gone on and are going on in so many different parts of the world, and that are linked together through these larger global institutions. So I think it's important in advocacy to not limit ourselves by the language of human rights and talk about broader systems, institutions whose responsibility is at play.
Thank you, James, for that plea towards creative thinking and also towards not thinking of the arms industry as an exception or subject to certain exceptionalism. Thank you so much to all of our speakers, and thank you as well, attendees, for joining us for this very interesting and lively discussion. I hope that we can meet here in the Forum of the Arms Trade in the near future to continue the conversations. For now, I will close and hand over to our host, Jeff Abramson, who will say a few words of closing. Jeff, over to you.
I'll let everyone go very quickly. Thanks so much. Great discussion. Lots of issues here raised. Really appreciate it. We will follow up with recommendations from the panelists. As you exit, please do fill in the survey and let us know how this went, and consider joining other events. Thanks so much to all. We'll do it.
Thank you, Jeff and Leon.
Thank you. Thank you, Shahd. Thanks, everybody. See you next time.